Hello everyone, I'm happy to open the fourth panel dealing with legal responses to violence. We have three speakers, each would speak for 15 minutes sharp. Then we would stop the debate, would open the debate for questions, and at the end we would have a commentator. So the first speaker would be Asli Olojai from the University of Glasgow, and she will speak about the role of international law in peace negotiations, certainty, legitimacy, and malleability. Did I pronounce your name correctly? Thank you. Asli obtained her LLB from the University of Bilkent, Turkey, LLM from the University of Cambridge, and she's pursuing her PhD at the University of Glasgow, where she teaches. And Asli specializes on the interface between international law and peace negotiation. Thank you very much.
Hi. In my presentation today, I'll first introduce the roles and functions attributed to international law in peace negotiations. And then through a case study of the recent Colombian peace negotiations, I will try to discuss whether international law can actually play these roles and functions that are attributed to it in this context. Since the end of the Cold War, there has been a dramatic increase in the number of peace agreements concluded to end internal armed conflicts. These agreements are, in most cases, concluded by armed groups and governments. Some 700 peace agreements in over 140 peace processes have been concluded in this period. And this practice of negotiated peace is characterized by three main features. It is increasingly formalized. Through formal peace negotiations, parties agree on written, comprehensive, formal peace agreements. And the practice is also increasingly internationalized. Various international actors assume different roles in peace negotiations, facilitation roles, funding negotiations, and they also assume various roles in the implementation of peace agreements. And an institutional architecture of peacemaking and peace building has emerged within the UN, but also within regional organizations to a lesser extent. This internationalization of the field of peacemaking has gradually brought forward a change in conflict resolution mindset, a shift from pragmatism, more conflict resolution mediation-based approaches to normativization, to law-based approaches to conflict resolution. There are increasingly more references to international law in the practice of negotiations, in negotiations and the outcome peace agreements, but also in international policy instruments, policy documents, and in the international legal scholarship. Especially international legal scholars have been quite active in this field, and they are, for the past decade, they have been discussing the emergence of a jus post bellum that also governs peace negotiations, or a law of peacemaking, lex pacificatoria. They also started to treat peace agreements as a legal category in itself. So accordingly, international law conditions the process and substance of peace negotiations. As to process, for example, it's been argued that women must be included in peace negotiations, or that perpetrators of international crimes should be excluded from peace talks. As to substance, it's been argued that certain issues like human rights protections or gender equality should be included in peace agreements as a matter of international law, or that certain issues, peacemaking modalities, should not be used in peacemaking processes. They are outlawed, like amnesties for international crimes or certain power-sharing arrangements. It's also argued by scholars and also by negotiating parties in some peace processes that peace agreements have international legal status, which was the case in Colombia, and I'll come back to that. So this increasing emphasis on the role of international law in peace negotiations is interwoven with a functionalist approach to international law. And by this, I mean that there is a tendency to look at what functions international law can play in peace negotiations, to determine the relevance of international law, and to argue to promote further legalization of the field. So what are the functions that are attributed to international law in peace negotiations. International law, the normative guidance international law provides, shapes the negotiation process, and it delineates the bargaining zone by clarifying that certain issues cannot be negotiated, or certain issues have to be negotiated. International law also provides normative guidelines for the design of institutions that are included in peace agreements, like international human rights standards for truth commissions. It is also argued that the resort to international law can also help protect the peace agreement against domestic legal challenges. By playing these roles, fulfilling these functions, the argument goes that international law brings certainty and legitimacy to peace negotiations. And international law does this in three main ways. First of all, it provides objective standards and a common language to negotiating parties whose relationship is characterized by deep mistrust and the threat of violence. In this way, it is believed that international legal norms can establish certain guarantees that enable rational bargaining in these processes, despite the cognitive barriers between parties. Secondly, international law provides for a certain degree of procedural legitimacy in two main ways. First of all, it facilitates the inclusion of certain underrepresented groups in the society in peace talks, like women, minorities, and it also creates a degree of equality between the negotiating parties, the governments and armed groups whose domestic legal statuses and political powers are not equal. And lastly, international law provides for substantive legitimacy in peace negotiations, and it provides certain guarantees against the co-option of the peacemaking movement by elites, by negotiating parties, at the expense of the interests of the broader public, of the underrepresented groups in society. And international law does this, according to this argument, by broadening participation in peace talks, by making the talks more inclusive, and by also facilitating the inclusion of certain issues like environmental protection, gender equality, or land reform in the negotiation agenda. I think these functionalist arguments about the role of international law in peace negotiations display certain contradictions, both in legal and in empirical terms. Legally, there is a lack of doctrinal analysis as to whether these norms that are assumed to fulfill these functions are part of existing law, whether they are applicable in the specific jurisdictions analyzed, and what their scopes are, how they should be interpreted. Secondly, the causal relationship between the reference to international law, to international legal norms, and the legitimacy and certainty in the process is not fully established in all cases. So through this case study of the 2012-2016 peace negotiations in Colombia, I will try to explore the roles, functions that international law played in this process, and I'll try to discuss whether there were any functionalist contradictions in this process. These peace negotiations were held between the Colombian government and the armed group FARC. The conflict had a 50-year-long history, and yet the negotiations ended with the conclusion of a final agreement, a comprehensive peace agreement, which is around 300 pages. In August 2016, the agreement was welcomed by the Security Council and the ICC prosecutor. But in October, the agreement was rejected by a plebiscite. It had to be renegotiated by the parties, taking into account the objections of domestic and international actors to the agreement, to its legality. And later that month, it was ratified by the Congress. There were a number of contentious issues about the agreement, but two of them were assumed to be the main reasons behind the defeat of the agreement at the plebiscite. And these were also, the discussions about these two issues were highly legalized by reference to international law, both by domestic actors and international actors. As to the legal status of the agreement, the parties originally envisaged that the agreement would be a special agreement as per Common Article 3 of the Geneva Conventions, and thus it would have international legal status. This was a strategic move by the parties because in Colombia there is the doctrine of constitutionality block. Certain international legal instruments are part of this document if they're about international human rights law or international humanitarian law. Once an instrument is part of the constitutionality block, it assumes constitutional status and it becomes a criterion in determining the constitutionality of future legislation and constitutional amendments. The original arrangement was that the agreement would be part of this block upon approval by plebiscite. This led to a significant concern about the loss of democratic control over the agreement and its implementation. The agreement was, the legislation implementing this arrangement was brought before the Colombian Constitutional Court, which conditionally upheld the law. The Colombian Constitutional Court held that the agreement could be submitted to a plebiscite, but it could not be part of constitutional law or Colombian law in general, even if it's approved by the plebiscite. But this didn't happen and the agreement was rejected by the plebiscite, so it was renegotiated. And in the new agreement, the parties had to take into account this democratic concern, the concern about democratic control over the agreement. They kept the reference to the special agreement status, but they clarified that the agreement would not be part of the constitution or the constitutionality block. The new arrangement is that there will be a transitional article added to the Colombian constitution, and through this article, the peace agreement's norms about human rights and humanitarian law standards will be interpretation parameters only for the legislation implementing the peace agreements. So in this instance, the reference to international law didn't bring much certainty to the negotiations and to the public debate about the negotiations for two main reasons. First of all, the legal argument that the peace agreement was a special agreement was overreaching. According to the Common Article 3 of the Geneva Conventions, agreements between governments and armed groups can have special agreement status to the extent that they bring into force international humanitarian law standards. It is true that there were humanitarian law related standards in the Colombian peace agreement, but referring to the entirety of the agreement as a special agreement could not be supported with this argument because the agreement contained various norms about land reform, illicit drugs, political participation of former guerrillas that were not really about international humanitarian law. And secondly, even if the peace agreement has special agreement status, this does not necessarily denote that the agreement has international legal status. This is a contested issue in scholarship. So this uncertainty in international law and the weakness of the legal argument used by the parties diminished the certainty that international law could have offered to the negotiating parties. As to legitimacy, instead of creating a sense of legitimacy, the reference to international law in this instance created a sense of illegitimacy because it was seen as an attempt to sideline judicial and democratic oversight. The second contentious issue about the agreement was the sub-agreement on the victims of the conflict. This was the transitional justice arrangement that was at the heart of the peace agreement. This is a very complex arrangement that has elements of truth, justice, reparation, and non-repetition. Various domestic and international actors opposed to the peace agreement because of this sub-agreement on transitional justice. They argued that certain elements of the transitional justice regime were not in compliance with the relevant international legal standards. The parties made ample references to international law in the sub-agreement, but this was again a strategic move because all the references were quite generic and vague without specifying which international legal obligations they are undertaking. This was to create a sense of legitimacy by referring to international law. But other actors also strategically instrumentalized international law during the negotiations. The former president of Colombia, Uribe, for example, a right-wing politician, has based his campaign on the illegality of the peace agreement from an international law point of view. His argument was that it was illegal to stipulate alternative criminal sanctions instead of prison terms for international crimes. He also argued that providing amnesties for the perpetrators of the crime of drug trafficking as a political crime was also illegal under international law. Neither of these was sustainable arguments from an international law perspective, but they were quite effective. I'm wrapping up. Again, in this instance, both because of the malleability of international law in this area to political instrumentalization and the uncertainty in international law as it relates to transitional justice, international law hasn't provided certainty to negotiations. And again, there was legitimacy, as to legitimacy, international law was strategically instrumentalized to mask certain concerns about the political concerns about the agreement, and this didn't create a sense of legitimacy about the agreement or about the opposition to the agreement. To conclude very quickly, my aim in this paper when highlighting these functionalist contradictions is not to refute the role of international law in peace negotiations, but it is only to qualify the arguments made in the practice, policy, and scholarship about the role of international law, and to highlight the complexity and contingency of the role. So this might inform further debates about the legalization of peacemaking or the relevance of existing international legal norms to peacemaking. Thank you very much.
Thank you very much, Asti. Now we will open the floor for comments or questions.
Thank you very much. Very interesting presentation. Probably relevant for the future of this city too. But I want to focus on one aspect and ask you about, you had, I think, on the first slide, stated that one of the advantages of law is objective standard, injecting into the process of objective standard. I wanted to ask if it's not a bit naive to think that law is objective, and if it cannot have an adverse effect on peace negotiations, because maybe peace is about getting to terms with the interests of the parties, while law drags them to positions, not to interests, and to a win-lose situation. I mean, the law has to be one or the other. It doesn't have place for compromise. So maybe you have an example of how objective standards have contributed in a Colombian aspect to our democracy.
Thank you.
Can I directly follow up on this one? When you look at the International Red Cross, for example, during peace treaty negotiations, and they work with Harvard, which you might know, the negotiation center. If you look at what kind of theories they use, because I think the whole thing is totally under-theorized and under-researched. They're not much further than getting to yes, which is a theory from 30 years ago. It is somehow bizarre to me. And that exactly comes back to the question of rationality. So I think the important thing when we talk about the role of international law is how international law can shape certain beliefs, or can kind of create focal points, or can de-bias the actors somehow. And there are many, many issues, and I hope, I'm talking to them in 2 weeks, and so I hope to do some experiments, because I think even the negotiators are not aware, or the mediators, they don't know. They're drawing on theories which are too old. But I think if you can focus more on the question, not only on, what I would do, the cognitive biases which you would find, but really the role of international law within. Don't start from the premise that it's objective. That would be, I think, using theories which we have left behind. So I want to pressure you a little bit on that. I think both. I think it was really the same direction. I just wanted to follow up on that.
Yes, maybe I wasn't clear enough in the presentation, but actually my aim in this paper is to question the claim that international law provides objective standards and it facilitates rational bargaining in these processes. There are certainly some contributions that international law made in this regard in peace negotiations. If we are looking for a positive example, for example, the debate about the definition of command responsibility in Colombia proved to be quite successful. It led to changes in some limited changes in the agreement, and there is an ongoing debate around this, and the ICC prosecutor mentioned this in the 2017 report on preliminary examination activities. So there might be further changes or legality challenges before either the Inter-American Court of Human Rights or the ICC. Should I hold this? This is fine, I guess. As to rational bargaining, I again agree. I think there needs to be more research done on the malleability of peace negotiations to rational bargaining, whether it is, or to what extent it is possible. We need to question this, and I agree about your comments on the getting to yes logic and using the old conflict resolution tools in the context of peace negotiations. As I mentioned in the examples from Colombia, I think we see that international law does not always provide objective standards. And even when it contains certain objective standards, these are open to strategic instrumentalization. The law itself is also contested, especially in these areas about the legal personality of armed groups, for example, the legal status of agreements concluded by armed groups, international legal norms that are relevant to transitional justice, like the prohibition of amnesties. So I think it is useful to both recognize that there's a limit to how rational the peace negotiations can be, how norm-following they can be, and also a recognition of the contested nature of international law itself, and there needs to be an attempt to build consensus around these norms, to engage with the politics of these norms themselves. So I agree with your comments, and that's actually my aim in this paper, to highlight that international law may fail to provide objective standards and rational bargaining guarantees.
Thank you very much. Further comments or questions? So maybe we will move to the second speaker. The second speaker is Shiri Reis from Deakin University of Melbourne, who will be speaking about when more international means less shared knowledge, experimental data on the impact of legal investigations in wartime controversies in the State of Israel. Shiri obtained her LLB with us at the law faculty. She obtained also a BA and MA at the Department of International Relations at this campus. She served as a legal advisor to Chief Justice Dorit Benish at the Israeli Supreme Court. And then she obtained her master's and doctorate at the University of Stanford, where she then served as a researcher. And recently she joined the Deakin Law School in Australia. And Shiri specializes on the interface between legal norms and fact-finding exercises. Thank you very much, Shiri.
Thank you.
15 minutes.
Sure. So thank you very much, and I really want to thank Yuval and Guy and Tomer and Moshe and Tal for inviting me to speak here, because it was especially important to me to present this project here in Jerusalem. So I think the last comments on the previous paper are really opening the stage for this paper, because my research question is, how do international law influence beliefs and attitudes in different contexts, including war crimes, police violence, and the context of refugees around the world. So this is a comparative project, and I field online survey experiments in different countries, including the US, Israel, and several other countries. I will present here findings from my experiment in Israel, because I thought it was most appropriate for this forum here in Jerusalem. But I'm happy to talk in the Q&A more about the other comparative aspects of this project. So, do fact-finding reports influence beliefs about facts? This is the case study or the project that I'll discuss here today. And I wanted to open with Operation Cast Lead, which was a massive Israeli offensive in the Gaza Strip taking place in December 2008. 22 days later, 9 Israelis were killed, about 1,400 Palestinians were killed, and thousands of Palestinians and hundreds of Israelis were injured. Thousands of Palestinians lost their homes. The devastation was horrendous. And during the course of hostilities, the international community, especially the Human Rights Council, decided to intervene by dispatching or establishing an international fact-finding mission to examine the facts on the ground, to determine what happened during the course of these 22 days, and appointed South African Justice, Jewish South African Justice Richard Golson to head this fact-finding mission. So months and months later, after thousands of pages of testimonies, the visiting Gaza, Israel refused to cooperate with the mission, so the mission did not have any access to Israel proper or to the occupied Palestinian territories in the West Bank. And the result was a 452-page report that detailed a lot of the findings of this mission. Interestingly, or perhaps not that interestingly, because that was the mandate designed by the Human Rights Council, the fact-finding mission did not really thought about the facts as something that would be separate from the legal interpretations of these facts. And perhaps that was one of the reasons for the Israeli response for that report. So just to give you a little bit about what happened immediately after the release of the report. The Israeli government, parliament, state authorities were really responded very harshly to the report. Ministers used words like the report is a political assault directed against Israel. It is vicious and unfounded, distorted, false, and irresponsible. Justice Goldstone himself was under severe attack, personal severe attack against himself and his family, was called anti-Semite, being a Jewish himself, and Shimon Peres, the left-wing president of the State of Israel at the time, called him a small man devoid of any sense of justice. So the response by the authorities was really very strong and very negative. Public opinion in Israel was not much different from that kind of governmental institutional approach to the report and its work and the mission's work. So 93% of Jewish Israelis thought that the report was biased against the IDF. 79% of Jewish Israelis thought that the IDF did not commit any war crime and any findings to the contrary are false. But what I found to be really astounding was that 64% of Jewish Israelis thought that the IDF soldiers that testified before the mission, testifying for participating or witnessing the commission of war crimes themselves, were lying. And I couldn't believe it. I thought, well, why do we think that the soldiers who fight for us, who we ourselves sent to the front, are not speaking the truth? Why do we denounce them as liars and traitors even? And specifically soldiers who do break the silence in Israel and talk about their own personal experiences in the military are really considered traitors by a majority of Israeli population and the government and the parliament, who are enacting different kinds of bills against such NGOs. So I thought, well, this is something that we should really think about, because this is a phenomenon that we should acknowledge, we should face it, and we should think about what is the reason, and can we do it differently? Is there a way to discuss facts in a way that would not cause the majority of Jewish Israelis to think that our own soldiers are lying? And that got me thinking about the process that I describe as the legalization of truth in international fact-finding. And I think we have different options when we're conducting fact-finding. We can do, I think the main idea is that we don't need lawyers necessarily to collect facts or to describe facts. And if we do assign this task to lawyers, we have to acknowledge that we are making a choice about the story that we are about to tell. Because legal facts are very different from historical facts, from narrative facts, from social facts. We have different stories that can be told, and the legal truth has a very distinct features, one of which is that it can't really allow different narratives to coexist, and it only allows very limited amount of facts to be a part of the story. So facts that are not relevant for the specific concrete legal questions will not be considered, or facts that are inadmissible in court will not be considered either. Could be, but we have very different story that is told when we are selecting to tell this story by lawyers who collect legal facts to do that. And so I think that, and it's really interesting, because when I was working on another paper on describing this phenomenon of legalization of truth, I found that the international UN rapporteurs and people in the international community are typically referring to these specific reports as reports that are the facts speaks for themselves. But this is not the case. The facts do not speak for themselves, and in fact, the law is speaking for them. And my argument is that this legal argumentation, legal description of the facts have some price with regard to the dissemination of these facts to different audiences, because the legal blame triggers different social processes and cognitive biases that prevent people from cooperating or from telling the whole truth or from taking partly responsibility for their own actions. Because if you are considered a war criminal, there is a huge price to pay, and people do not see themselves as such. And I think we can definitely learn in that regard from the literature on aviation catastrophes or medical negligence, when we are thinking about blame-free regimes, because we want to encourage a systemic change rather than to assign individual blame on specific people. So that is kind of the background for the argument that I developed through empirical work. And so, based on this theoretical framework, I'm asking, can international fact-finding reports mitigate controversies about facts? Looking back at the Goldstone report, we can definitely see that the Goldstone report did not mitigate the controversy about what happened. To this day, we don't know how many Palestinians were killed during Operation Cast Lead. We don't know how many of them were civilians. We don't even agree on who are civilians in this context. So in that case, it did not mitigate controversies. So what I decided to do is to design an survey experiment. This one was fielded in 2017. exactly a year ago, on a representative sample of 2,000 Jewish Israeli nationals. And specifically, I was measuring the perceived credibility and the believability of the facts with regard to fact-finding reports in the Israeli-Palestinian conflict. My dependent variables, what influenced that outcome was different levels of legal blame. So whether the report would be absolving, would be neutral, or be incriminating. And in the incriminating area, I used different types of legal blame. So for example, violation language versus war crime, the more kind of stronger legal blame. And another aspect that I varied was the institution, because I thought the legitimacy of the international institution rendering those facts or establishing those facts would also be important. So in that specific experiment, I used the United Nations and the Israeli Ministry of Defense. The facts were pretty simple. Kind of looking back at different fact-finding reports in that context. I used a vignette in which Hamas fighter detonated a bomb which killed IDF soldier. Other soldiers who witnessed the attack chased the Hamas fighter into a nearby marketplace, shooting repeatedly. They killed the fighter as well as 14 unarmed civilians. And the conclusions were that the IDF soldiers did not violate international law, that the Commission cannot determine, based on the facts, whether international was violated or not, that the IDF soldiers violated international law, or that the IDF soldiers committed war crimes. Now, what I found was, as expected, that the level of blame dramatically influenced the willingness to believe the facts or the perception of the report fairness, which is the other graph. So we can see from no violation at all to war crimes, we can see a dramatic drop in the willingness to believe the facts and in the perception of the report as being fair and unbiased. I had many other variables, but due to lack of time, I'll just present those important ones. But I think it's interesting to see that in the no conclusions, in both variables here, we can see that there was not a strong either support or objection to the report, while when we use the no violation judgment or conclusion, no blame area, then Israelis would believe the facts that 14 Palestinians were killed, while when we use the war crime scenario, almost a very small portion of Israelis believe that 14 civilians were killed by IDF soldiers. Again, we can see that when I measure anger towards the report, then we can see that the war crime, the last one there, the war crime judgment really triggered very high levels of anger towards the report. However, the level of blame did not at all matter for the guilt, for feeling guilty about what happened. So when I told them the IDF did not violate any norm, or that the IDF committed war crimes, it did not matter at all for whether people felt guilty for what happened in any sense. Or it also worked for empathy with the Palestinian victims. And then the institution aspect of it was that, as we can see, and obviously as was expected, when the United Nations issued those the report, the belief of Jewish Israelis in the report was very low, while in the Israeli Ministry of Defense report there was much greater willingness to believe the facts. And we can see that here based on the different levels of blame. So basically the only positive response for the or willingness to believe the United Nations report was only in the condition where it's explicitly said the IDF soldiers did not violate any norm at all. Okay, so, yep, I'm right on time. So, I have lots of other variables and measures, and I'm happy to talk about this in the Q&A. But just to conclude in a sentence, in our area, in our time where fake news is the catchphrase of the moment, and where the production of facts always trigger the production of alternative facts, we have to start thinking more seriously about how to conduct international fact-finding in a way that would trigger less of a negative response or less of a denial. I cannot really talk in positive terms of how we can make everyone believe the truth, but I think we have some ways that we can at least try to mitigate those outcomes so that international fact-finding will not end up intensifying the very controversies that it was designed to resolve. Thank you very much.
Thank you very much, Shiri. And we would open the floor for comments. Maybe I would abuse my position and share with you some small reservations. And I think that one of the implicit assumptions of your work is that the main or maybe the principal subject matter of the fact-finding mission is the domestic public or domestic political elite, but it need not be the case in all cases, in the sense that, for example, in our case, the Goldstone report, maybe the clients do not sit in Tel Aviv, but rather in Geneva or New York. So that's one reservation. The second reservation is that you refer to the failure of the report to mitigate conflicting positions because of this aggressive terminology. But again, the task of such a report need not be to mitigate conflicting positions. And my third reservation would be that you rely on political blah blah of Shimon Peres, etc., maybe to prove the fact that this aggressive terminology is counterproductive. But I think that the way to assess the effectiveness of such a report is not to rely only on political responses, but actually on concrete changes. So in this room, there are few people who I believe can attest the fact that this aggressive report with a reference to war crimes actually triggered some non-insignificant changes within the Israeli legal apparatus in the army and elsewhere. So these are my reservations, and I would be also interesting. The rumors say that you conduct nowadays a very similar research with a different focus, namely the use of human rights terminology with respect to refugees, and I would be interested to read the publication when it would be with us. So let's open the floor. Maybe we go from here to here. So Tal.
Thank you.
But maybe because we are pressed with time, so very focused. Yes.
Okay, so thank you very much. Very interesting. Specifically relating the experiment, I think that the fact that you're using Hamas on Israeli participants, it creates a limited, it creates a conclusion which is limited, which is not general in its character, because in Israel, Hamas is very, for most Israelis, Hamas represents something, and in addition, there were cases where Hamas was captured directing fake news, and therefore I think that the experiment or the ability to actually understand how do Israelis feel about fact-finding missions is limited because of the choice to use Hamas. On a more general level, in relation to your conclusion, you want the truth of fact-finding committees to be more valuable, to be used in a positive way. And the reason why it is not used in a positive way, or why it is perceived as something which is not credible, is because there are no rules of evidence. There are no rules of evidence which are parallel to other tribunals. And when you speak of a legal truth, we think about a tribunal. But there are no rules of evidence. And even Sharif Bassiouni, which was nominated to head a committee, decided out of an ethical consideration to retire from the committee because he said nobody cares here about the truth. So I think that this is the main problem with credibility. Sorry if it was too long.
You want to collect them or
Yeah,
ping
I
pong?
think we'll collect them because
Okay.
it's important. So.
Donald?
Yeah, we can talk about this later. I think maybe picking up on a few things already mentioned, I encourage you to sum up, put it within the frame of peace versus justice, because I think that's really what we're talking about, ultimately, and the effectiveness. And there is that tension, what was the contribution of fact-finding, credibility, and so on. And of course, the Israeli question is, to what extent is this, and I'm not going to say external, well, I already said external validity, but to what extent is this, is this an Israeli story with the ingrained skepticism towards international law, international institutions, because you don't have a benchmark, aren't you, have asked people to begin with and probably have similar results regardless of the outcomes. There is some research I've been exposed to recently in Kyrgyzstan, between the Kyrgyz and Tajiks and their acceptance of the idea of international criminal investigations, so we can follow up on that later.
Thanks.
Thank you, Tom. Alexandra?
Hi, really thank you for a fascinating presentation. So my question is basically comes from my own research that I've done on fake news, alternative facts, and international law. And so while you were talking, the only thing I was thinking of, and this is me projecting my own work onto you, is like the emotional reactions that are triggered by these fact-finding missions. And so to me, maybe what you're heading towards is an emotionally sensitive fact-finding mission. And yeah, the way of like doing this work without emitting a judgment. Because even if you would come up with rules of evidence, I mean, rules can always be twisted and turned and interpreted in order to go within your perception and your belief system. So I don't know if maybe it's like rules won't help in this situation, or like another way of carrying out fact-finding, or figuring out how we can actually mediate and present facts in a way that it's not confrontational, and that because it's the resistance that it triggers, because it's a threat to how you perceive the situation as well. So.
Should I continue?
As long as you have time, I prefer to collect.
Thank you. 3 very short points. 2 regarding external validity, sorry, Tomer, and 1 regarding the normative implications. So, I saw that you briefly mentioned it in the limitation section, but I think that it's really important, and I want to hear your justification for your choice. So first, no one in the general public reads the Goldstone report or any report. It's mediated to the public through the media, through other sectors. And so how can we know that the language that is used in the report will reach the general public? Maybe they'll say in the report that there was no violation, and in the papers they will say, well, Goldstone said that Israel committed war crimes. So I think that you should support, if you have normative implications, you should demonstrate that the language that was used in the newspaper is similar to the language that was used in the report, in order to demonstrate the external validity of the potential change in the language of the report. Second, I think that I wasn't really, I was curious on your decision to use this very vague scenario regarding the legality, because this is a clear case where the facts themselves isn't really saying clearly that there was something wrong that happened. And I would think that in a case of a fact-finding mission that will focus only on the facts, will say Israel intentionally killed 1,000 civilians. I would say that the believability of these mere facts will be highly contested in the population. And if we talk about fact-finding missions regarding mass atrocities and these kinds of stuff, I think that you should provide significant justification of the use of your specific scenario. And finally, regarding the normative justification or implications, I think that it's a separate discussion that you need, again, to address more fully. So, for example, you demonstrate that if it's an Israeli fact-finding mission, it produces greater believability, but you don't suggest, it's one of the normative implications, maybe we should have only national fact-finding missions, right? From obvious reasons, but again, it's not an implication that results from your experiment. And so again, you need to demonstrate that the domestic constituency is the audience, that the normative significance of legal conclusions is unimportant, and so on, in order to justify.
Thank you, Ali. 2 last remarks, yes, please.
I find this research absolutely fascinating, and I was stunned when 2 years ago I read Marko Milanovic's paper on how the ICTY findings were looked in the Balkans and in Serbia, and it was exactly the same thing. So there was no evidence issue here. It's just that people have denials. And so where does this come from? And I think this is the question I would like to ask you about. There is obviously a psychological mechanism. I'm not a psychologist, but I've read a lot on it, and I think it must be some kind of reduction of cognitive dissonance. So you can't interpret really, I mean, it's very clear if you say there's a war crime, right? So you put the legal label on it, it's a war crime. Nobody can, except for him or herself, that they would be sustaining war crimes. So you have to do something on the factual side in order to uphold your own image. And I think this is what's happening here. But I would like really, exactly with the reaction I'm seeing here in the room, I would really ask you, I totally understand you took that example, but you know, make sure that we have other examples from other regions where there was a court. There was not an issue of evidence, it's a psychological question of how people react to that. So I find your suggestion, I mean, given that no information is needed, no fact is needed, you alluded to some of it, right? Already how we select, the law does it for us, but if you want to take the law out of the picture, we need some other kind of ideas and preconceptions of what kind of facts we are looking at, because we can't look at everything, right? We can't look at whether there was breakfast on the table or not. That might not be interesting. Maybe it might, but probably not. So some kind of selection. I think, well, since you do policy advice, I think you need to find a solution on how to select this kind of information you're getting. And then I think you alluded to it, and I would like to know a little bit more about that. What would be the measure so that you have like maybe non-lawyers gathering the information and then give it to a completely different body who's doing the legal analysis, or how would that work? Or would it go being a back and forth, or?
We
have more?
I simply cannot say no. That's my problem. Yael and Moshe, but please keep it short.
Add one sentence. It's not only psychological, I think, it is also that we are a member of the Israeli community. It is social cognitive lenses. I mean, like in Serbia, in Israel, in any community, there are some cognitive screening operations.
Yael, yes.
I'm looking at the title, Legal Blame and Hinder Dissemination of Facts. And you're suggesting, so how do we collect the facts? And I wonder, does it not all boil down to what do we do with the legal blame? Doesn't matter who collects the facts. And if we can manipulate that, I'm not using the negative word here, whichever way we want, as long as we know that what's on the card is eventually going to be legal blame, then that's going to fix it. So, and you said that you gave the example of aerial catastrophes and medical negligence. The legal blame was taken out. Right. That's all.
And I'll be
Not
really.
that I'm suggesting to cancel the idea of war crimes, if anybody thinks that's what I'm saying, but isn't that the...
I thank you for pushing me in that regard, because I actually should have said I promote a blame-free approach to war crimes. Yes, I am, and I have to say it out loud, but I will say it, because I do think that will trigger the systemic change that is so much needed. And I have on my paper on the legalization of truth, I say it in regard to the US bombing of Doctors Without Borders hospital in Kunduz, Afghanistan, where Doctors Without Borders wants criminal justice. And I think if we want to prevent the bombing of the next hospital, we need to look at it not from the perspective of who is the soldiers that we need to put behind bars. But I know that I don't have time to respond to everything. I have to respond to Yali's middle comment about my vague scenario, because I think that really makes my point. I have a scenario where IDF soldiers go into a marketplace, shoots repeatedly everywhere around them, killing 14 civilians. How vague is it? You're talking about thousands of people. That's genocide, or could be genocide. So I specifically am interested in the issue of war crimes, because I think that it's important to really think about this thing. I think in Israeli society, we think about war crimes as equivalent to genocide. If it's not a deliberate attack on thousands of children, and you know what, even in all those, in Goldstone, in Kaslet operation, and 3 years ago, during, I don't remember what's name, Operation Protective Edge, 800 children were killed. Isn't that enough? Did that promote more believability in Israeli society about the facts on the ground? I actually thought that I have to use a more mellow vignette in order to have the attention. Because I think, from my experience, trying different type of vignette, and before that I pay, let's say, $40,000 per experiment, I do pre-tests on a kind of non-representative samples. And so I've I've played around with different manipulations that really kind of see what would capture my idea best. And my experience with Israeli society, which is different from my experience with other societies, is that when Israelis hear something about killing hundreds of children, they immediately deny it. Because that's just unheard of, it's unthinkable. So I had to choose something more mellow, which is definitely a war crime.
The point, right? That the facts themselves, not only the legal result, affects the believability. You just said that in other scenarios, there wasn't...
No, it would have made my case easier. So I would definitely make my point, because for Israelis, they would just deny it. And I think that would make my point. But then someone would tell me, yeah, but that's really... we can't even believe something that horrible would happen without any provocation. So the idea was that this is really a war crime. But I think the legal blame here is I wanted to see what would happen when we use different legal languages or different rhetorics or different framing of the facts. And you can't really do that when you use a genocide scenario, and I think it's less interesting in that type of scenario. I think only the type of scenario that is really explicitly war crime. And I think really shooting at 14 civilians in a marketplace, that's a war crime. So when we look at the facts, I don't think many international lawyers would say this is not a war crime. But I do think that that's one problem with the legal language, that the public perceives war crimes as equivalent to genocide. And we don't have that kind of more fine-grained understanding of the different legal framings, which is one of the factors that then trigger denial. But I don't have time to respond anymore, so thank you very much for the comments.
To be continued. Church was supposed to be our third speaker, but he apologized for not being able to attend due to sickness, and we are very grateful for Felix Lang, who fills his position. Felix obtained his BA at Law and Modern History at Freiburg and Berlin, LLM in New York University, and his PhD thesis about the history of international law won him a very prestigious prize. Felix is a researcher at Humboldt, and he would be speaking about the images of the international in constitutional democracies, treaty making and treaty implementation in the United States, Germany, India, and South Africa. And am I right that your poster would be presented in due course? Yes.
Yeah, thanks a lot. My poster will be presented later, but I thought it would be a great chance to present my thoughts about my upcoming book project here. It's rather a book project than a fully researched paper. And I have to excuse, it's not really related to violence because I jumped in on the last minute, but I hope it's related to the largest theme of the conference, International Law in Times of Disorder and Contestation. And I have to thank Maria for agreeing to even read the paper, even though it was sent to you yesterday, and it was rather an old version of the paper, and my thoughts evolved. So now I'm going to try to contextualize the empirical findings, which I threw at you kind of with that paper. So my research questions are, how and why are universal multilateral treaties signed, ratified, unsigned, terminated, internalized in different democracies? And do we see changes over the respective approaches by the executive, legislature, and judiciaries? The title of my paper, Changing Images of International Law, is of course a reference to Wolfgang Friedman's famous Changing Structure of International Law, written in 1965, where he argued that besides the law of coexistence and law of coordination, we now have an evolving law of cooperation. And he based his claim particularly on the multilateralization after the Second World War and the rising importance of international institutions. And I'm now starting with the idea, what happens to this law of coordination, which has become so entrenched in the 1990s, in particular right now in these times where there are some challenges and some backlash. And I thought that the idea of images might be better suited for my research interest because it's a plural, it's not a changing structure, I don't need to grant narrative, but I can differentiate, make a multi-causal claim, and look not only at the difference between the countries, but also at the difference between the respective constitutional actors. Furthermore, the idea of images signals that actors approach international with a certain vision in mind, and this vision is shaped by the respective political and cultural understandings. So I thought this terminology is suitable. Some thoughts about my methodological approach. So Anthea Roberts' book about comparative international law is now on everybody's lips. She focused on the P5 and on academic cultures and textbooks. I'm focusing on these 4 countries and the executive, parliaments, and judiciary. And while I think her work is really important for the self-reflection of the invisible or divisible college, I think it's also very important to ask with what kind of different pre-understandings do certain actors approach international law, and from that we can maybe also think about how we can address this. So my research is informed by our scholarship. I'm reading a lot on of Mark Pollack's support of international law. He tried to analyze how we can develop a theory to understand what support means, and also some other IR scholarship. But I'm not gonna follow the method of process tracing and variable testing, but rather try to read all the sources and then make some plausible causal inferences. It's kind of the historical method, and even though it's not a very historical theme, but contemporary history now also tends to take a position on questions coming very close to the present, and this is the methodological approach which I draw from, because I think it's so important also to think about the causalities and not only describe certain developments. The case selection, of course, that's an issue. Why these 4 countries? I think they are representative of different images of international law, at least to some degree. I mean, there's literature that the US is from Mars and Europe is from Venus. The US is regarded, especially during the Bush administration, as a rough state. Germany has this reputation of having a particular legalist, law-abiding image. And also with South Africa, at least until recently, when the story was told that as a countermove to apartheid, it started to embrace international law, especially under Nelson Mandela, while India belongs to this group of Asian states which are said to represent a more ambivalent approach to international law. Furthermore, these are influential democracies. I'm not saying that my claims will be generalizable, but I wanted to pick some countries which are politically, economically, and also intellectually important, and what's important from different reasons, not only from Western countries, but to have like 2 countries from the global north and global south and see what's happening there. And why I picked democracies has also to do because I'm interested in the different foreign relations law, and ask the question, what does constitutional design, does it matter? So in India, the executive decides alone which treaties to sign and ratify. In the US, you have this 2/3 Senate majority to approve some international treaties. And in Germany and South Africa, you have a simple majority. So does this different institutional designs or constitutional designs matter for the images of international law? I'm now shortly going to throw at you kind of the evidence which might lead into the direction that we are living in a world of changing images of international law. We've talked about some of these examples before, so I'm just going to be really short. We have this withdrawals, the ICC withdrawal, and also the disbanding of the SADC tribunals, individual complaint mechanism in South Africa. We have Trump and his America First policy, how it's related to multilateral treaties, the unsigning of TPP, withdrawing from UNESCO and the Paris Climate Accord. And in India, we have not withdrawal, but termination of BITs and a new model BIT, which is set to bring the state back in to take a more assertive approach to shaping international law. Then we have, of course, instances of non-signing. We have disarmament treaties and human rights treaties in the US and India. Of course, there has been a long continuity in this. This seems to be not a very novel development. But we also have, since the 2010s in Germany, the interesting development that there are street protests kind of leading to questioning major trade agreements, like the ACTA agreement, which failed in 2012 in the European Parliament after critics had gone to the streets. And even though CETA has been negotiated and concluded, it's had been under a lot of pressure by social movements, in particular from sympathizing with the left, one could say. And TTIP, of course, is under pressure in Germany and on hold, but also because of the American presidency. Further evidence for changing images is the layering, what I call layering, or what others have called layering. So especially states from the global south establish alternative institutions like the New Development Bank or the Asian Infrastructure Investment Bank. And some people claim that thereby they're circumventing the universal institutions like the World Bank and the Asian Development Bank, and especially the oversight mechanism, because they don't want an inspection panel, and they just want the money to get more easily to them. Another of the kind of these institutions is the Malabo Protocol on the African Court of Criminal, on an African court which deals with international criminal law. This is nowhere near of being signed by and ratified by a lot of states, but it shows that there are these ideas out there. Another point is what I call veto pressure into non-binding obligations. So the Iran deal and the Paris Climate Accord, they contain some non-binding obligations. The Paris Climate Accord, of course, lots of binding obligation in relation to the oversight mechanisms, but American negotiators were really pushed for using rather non-binding language, the should instead of the shall, because they didn't want the Senate or the Congress to get involved in the ratification process. Then we also have courts, which are isolating themselves from international law, the famous well-discussed Medellin judgments, even though it's a little bit older, from 2008. And in Germany, we have this constitutional identity, in which the Constitutional Court tests or points to limits of international treaties and says, and this was not only applied to the Lisbon Treaty, but recently in a preliminary judgment also to the CETA Treaty. So there are some concerns by the Constitutional Court. But this, of course, is not this, a simple story in the one direction. We also have counter evidence. So ratifications continue, especially in Germany and South Africa. We have embracement by courts of international law. So especially the Indian Supreme Court, but also the South African Constitutional Court, use international law to instigate domestic reforms. In the United States and Germany, there's affirmative reference to especially the ECTHR judgments in the German case, and the US we had this Roper and Simmons from 2005. And we have the South African High Court, it was talked about yesterday, who brought kind of parliament back into the decision-making process about the withdrawal from the ICC, and so this withdrawal has not taken place. And because we have a change in leadership, we might see that Ramaphosa is taking a slightly different perspective. We don't know yet. A further sign of counter-evidence is that other actors step in. So even though Trump declares that he will leave the Paris Climate Accord, of course there's also this notification period, and it will take some time until he gets out. But there are cities and corporations who can't become part of the Climate Accord, but who pledge to follow the Paris Climate Accord. So what to do with all this evidence pointing into two directions, and there are competing theories, or I should rather say narratives out there, which tell us what's happening in international law right now. So there's this rising powers narrative, which is somewhat reflected in what India and South Africa are doing with these alternative institutions. But one also has to see the resilience of international institutions, or at least of human rights in international institutions. It's interesting that the Asian Investment Infrastructure Bank included some provisions on environmental and social standards, because there are also now non-Asian partners or parties to the new multilateral organization. So it remains open if it's really going to be investment, or if they're not going to care about human rights at all. Then you have populism, of course, with Trump and the post-human rights era, especially conservative American international lawyers argue that human rights are over. But more optimistic liberals like Harold Koh recently has written on Trump and international law, arguing that we have these transnational legal processes, so we shouldn't worry. So it's cities, corporations, domestic courts, they all jump in, and this is also partly reflected in my research, and I will engage with this theory as well. And also by political scientists here, I don't think, like Bashak, that they only tell like one story. Of course, they have this end of liberal internationalism, but there's also this story of contestation and politicization that is just natural if you have more multilateral institutions who make general claims or who have larger decision-making powers, that it leads to contestation and politicization, and we will adapt and somehow be able to respond to the needs. So I'd like to conclude with my findings, which are very preliminary. So I had the impression that that there is really something happening, which hasn't happened since quite some time. So we have geopolitical shifts and globalization skepticism from the right and left, which transform the respective images of international law. So there's something we really need to take into account and deal with, and see what this will do with international law in the future. However, I'm much more skeptical than others that this will be now the new sovereigntist age. So because China, Russia, and also India, South Africa are rising, human rights will be sidelined because as of now it shows that executives with ratifying treaties, but also national courts and other actors mitigate the backlash and fight back, kind of. So it's not that dim. So when I would make sense of it right now, we all know Joseph Weiler's famous article about the geology of international law, and there he talks about the different layers. And maybe we are in a time where this layer of law of cooperation, which has become dominating during the 1990s, gets a little bit smaller, and the sovereigntist layer gets a little bit bigger, but it's not like a fundamental change in the sense of Friedman. Yeah, thank you.
Thank you very much, Felix, for your nuanced expose and analysis. Any comments? Okay, so maybe Maria can answer. Maria Isabella would offer her comments. Maria is a practicing lawyer and managing partner of Freeport in Moscow. Previously, she worked at White & Case in Moscow, and she argues cases before the European Court of Human Rights in Strasbourg. She holds various prestigious awards, and she plays a very central role in the JSOP competition. Thank you very much, Maria.
Thank you very much to all the presenters. Those were very enriching and interesting papers that I've read. Despite even the shortage of time I had, I learned a lot from Felix's paper yesterday. So I'll go one by one, and because I think we're a bit short of time, so I'll try to limit the comments to the most important points, especially that some of them have already been discussed. So Asli, that's a very topical paper, and the Colombian treaty process was extremely interesting to read, also very concisely written. You've developed it a bit in your presentations, but my comments would mostly be limited to how I perceive the writing, because I think you will be working on it further. So basically, I wanted to point to where you point to an increased use of public international law, language in peace treaty processes, and in treaty provisions. I was wondering if this is a specific thing for the peace treaty negotiations, or maybe it's part of a broader phenomenon of using more legal language in general international law, because, well, obviously in the past, I mean, even if you take use of force, states would go without any justification. Now, the legal language, I mean, they use justifications all the time. So this is kind of part of this phenomenon that you may want to discuss. So I was just wondering what is your thought about it, because you just mentioned it in passing. Then there are several points in respect of your arguments concerning how public international law affects peace treaty negotiations and provisions. And when you speak, for example, about equality between the parties that PIL brings and kind of mitigates asymmetry, well, that is true to an extent, that it's a very interesting point, yet it could be true only to negotiations at best, because when we look at reparations, for example, there are very rare cases, only one I believe, where reparations were paid by non-state actors, whereas states are bound to pay. So in a way, non-state actors and states, they commit, non-state actors can commit IHL violations, yet it would only be states that are required to remedy it by international law. And in a way, that symmetry can be more apparent than real, something that you're talking about. Also, I was not sure, and also maybe you want to be more clear whether you talk about it in a way of criticizing it, or you accept it as part of international, but when you speak about, like, for example, well, mostly about inclusion of certain groups as influence of international on the peace treaty processes, I was not really sure that well, at best it could be soft norms of international law, but we don't really have many provisions on the inclusion of women, like gender balance. International courts and tribunals don't really have those procedures, for example. So many things that are really not kind of established international. So and then also it was not really clear to me if it's part of this criticism that you attach to the functional approach, or that's something that you agree with when you make this argument. Also, so maybe that's just basically being too optimistic in terms of what international law has to offer in this regard. So I also thought that when you use such terms as legitimacy in your section 2 and maybe certainty and others, that you do not define them, but then you use them as benchmarks for assessing the role of international law, and it's also like, I think, requires some clarification and more development, because like we all kind of know what legitimacy is something good, but how exactly and what do we mean by it remains. So I thought that could be like a bit more developed. So in a way, to conclude, when you think that the negative effect can be imposed by using too much PIL and public international law and excessive legalization, I thought that maybe you want to develop more on what exactly, what international law and when you want, and more like in what way. Because do you want less legal wording, or you want more incorporation just by reference to PIL rather than stipulating particular facts? So I thought that it also could be improved. But otherwise, thank you very much. I learned a lot from this paper, and congratulations on submitting it to the forum, despite the pressures that you faced, as I understand. So, Shira. Basically, I agree with Anne. I was absolutely fascinated. It's also part of some of the potential topics we are thinking about of doing in our like kind of academic practice in Russia, and maybe the European Court of the level of the European Court of Human Rights issues. So I thought that the results of your surveys were very, very interesting, and kind of I find them very curious. Although in a way they're very grim to an ear of an international lawyer. So in a way, we are looking at the legality not helping. So our primary task, as Bashak was saying, is not helping us to reach out to people. And obviously it touches upon the issues that Marco has raised recently, and I was also very interested in reading the analysis, which is also very sad, and kind of in a way it can make you really depressed in questioning our profession. But I think that, I mean, one important point here is that, at least in my experience, I can see that many lawyers presume that when we speak and we present information in a legal way, it bears more authority with it. And we kind of accept it as a like basis of everything. So it's an authoritative language, so there is just automatically more persuasion. And it's even more, we can even go with this perception that it's more reliable and trustworthy than any other form of communication of information. I don't know if it, like, all of you had different experiences, but at least I think in my environment, we tend to take it for granted, kind of. So it was even more interesting to see that actually, so we started to see that it's not true. And if we look outside of the, so it's not only true, but only works to the contrary, like that it provokes denial and defensiveness in the audiences. But in a way, if you think outside of the legal frame, that's very understandable, because law is a very specific language, and if you think about it, we speak in like shortcuts and labels, and we use some benchmarks, but they're meaningless to us. So, and that's the language that is used by among mostly like legal profession and state authorities, so very specific categories. But again, the cognitive science helps us in this regard because we now know, and art, and in particular cinema and literature, they do discuss that our minds, they speak a completely different type of the language. So in a way, it is a well-known fact that now that our mind likes to draw conclusions itself from a variety of pieces of information presented to it. So it's its natural habit. Whereas just presenting ready formulas is this like dry lecturing, it's not interesting. So in a way, as lawyers, we present those already made formulas. And that's really not something that pierces through our mind processes as individuals. So those are completely different, two different things. So in a way, so basically, another point is that we think in the format of a narrative, and with the situations in heads, we basically are discussing the clashes of two narratives. And I don't think that legal profession and legal language as such has ever been designed to work with a narrative or to somehow overcome it. Like, for example, I was thinking that, so in Russia, for example, we have many Article 3 cases. So the torture in police departments has been discussed like in multitude of cases at the European Court of Human Rights, but the indifference of the public, it has never helped to combat it. And once, several years ago, in one of the Russian regions, there was a case of torture. So a personal story somehow it came out through a journalist or maybe through some blogs. And like then we had a wave of attention from the public. I mean, there were publications, shares, there was protests, there were protests, there was this massive emotion provoked. So I asked myself, why? Like, as a lawyer, I've known about these facts for so many years, why people have not been waken up by the facts? Well, maybe now we're looking at the answer. Because those were told in a legal language. And the story told in the format of a judgment or a fact-finding mission is not something that our mind as individuals is ready to believe. So in a way, I would say, probably to conclude, that it's a natural thing, and we may be looking, just that we've been looking through our biases, as cognitive biases, as professional biases, as lawyers before. So more studies are needed at the moment. I think it's interdisciplinary, so we need to reach out. Plus, also, importantly, if we think what plays against us as international lawyers is time and history, because the international narrative is very new compared to national narratives that produce conflicts. And if you look at domestic audiences, they do not engage with, if you look at domestic authorities, they do not engage with their audiences through legal language only. I mean, they have lots of information channels, whereas we as international lawyers tend to communicate only through official papers. So in a way, there needs to be some reinforcement. So obviously, we may be looking at a situation where like just a speech by an international lawyer is not sufficient. Well, now we need to find a solution what to do about it. So, and I hope we will prevail at some point. So Felix, I read your paper with great interest. I thought it's very well structured. So we get both the information on how the processes function in each of the countries you are discussing, and then you get information, and a lot of this information was new to me, also very relevant. So thanks a lot for sending this paper. I understand that it will be a book and it will be more developed, but it was really, really enriching as well. So a couple of criticisms that I kind of picked up as I was reading it yesterday. I don't know, I mean, at least how it's formulated now, you ask this question very broadly. In a way, what is the role of international in the domestic, like executive, and then you discuss it, so you ask your questions not in regard of democracies only, and then you abruptly limit it to democracies. So that's where I was not exactly convinced. So at least maybe, I mean, if we didn't have this broad presentation in the beginning, I would have different expectations. But in a way, when I was reading it, I was forced to think that I'm not very convinced about the argument, how you frame your research. Especially when you say that non-democracies are likely to favor renationalization over internationalization. I mean, I'm not sure it's true, because, well, in terms of the international liberal order, I used to talk about, that's true, but isn't it the case that autocracies would like internationalism, but on their own terms? So in a way, I mean, again, Russia's backlash, obvious today, bears a lot of resemblances to the USSR. Was the USSR nationalist? It was very internationalist. And I mean, there is a lot of engagement if you look at Russia with BRICS, with Eurasian Union, with a lot of, ideas to expand. So in a way, I mean, maybe that's because it's formulated this. So I was thinking that you kind of lose the frame that I do not necessarily agree with. And also, basically, many of the trends you are discussing are either occurring or being imitated by autocracies. So that also makes maybe some comparison relevant in your research. I also found it curious that you question, so what you say is exactly about Germany. So you find it striking that the argument of domestic democracy plays such an important role in the jurisprudence of the Constitutional Court on international issues. So, and the court seems to be cautious to retain the right to disregard international law when principles of democracy are at stake. So because I was kind of along this line of thinking, I thought that maybe Germany actually has a protection against an international legal order that may one day turn to non-democratic values. And in a way, that's the risk we run in limiting the scope of research to democracy. So if there is, one day the internationalism turned upside down, we will have a very bad surprise. So in a way, I thought that the limitations you put in your paper, they create certain risks, so I wanted just to raise them today. Thank you.
Thank you very much.